I'm going with disagreeable.
Disagreeable.
Kind of like,
Yeah.
I'm like a cringe earnest person, so I went in trying really hard to find common ground, which I considered a huge win. I know it's so gross, but I forced in my attempt to do that, I forced both Cenk and Dave Smith to make what I thought to be pretty Zionist points at different parts of the.
Things are going to start happening to me now.
You've done all the reading. You're a scholar. You're a professor. You've done all the reading. You've done the intellectual heavy lifting.
More or less, eat shit and die.
You wouldn't know a fact if it begged you all night long.
Want to give the wrong impression because I am very high.
Ran up behind him with a hatchet. Smash, smash, smash.
Yeah. Care. I'm a libertarian. What I'm getting is,
did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
And welcome to the Libertarian Podcast Review. This is the Saturday edition. I have some apologies to make because I see in the chat, oh my God, I can't wait. Ron, 2 beers, and then JC's like 2 hours, and then there's a bike emoji. Oh my God, 16 hours to go. So here's the deal. I had this scheduled as typical Friday afternoon, 4 Pacific, 7 Eastern, and then I got contacted by Top Lobster and Josie, the redheaded libertarian. They wanted me to help them out with a Spaces debate. Mark Pellegrino, Clint Russell, and I was like, sure, why not? So I put this off, and then I was going to just do it afterwards. And then that thing went for an hour and a half or longer. And then I just was like, what? I didn't feel like doing it. But here I am. Saturday, I still, because this is the crazy thing. So you do it for clout, right? Which is, you get in this big spaces. I got quite a few good followers from that. That helps. Pushed my show out a little bit, and it was a nice, and at some point I'd like to be able to be involved in these. So, you do it a little bit for that. You help out a little bit, hoping to get a little bit back. But I have what I considered a banger show going here set for Friday. Minder, it is live. Yes, this is live. And so I thought I had a great show going yesterday. And so we're putting it out today. So hopefully it'll still be beneficial for everybody. I'm going to play some clips. I'm going to go through some things. I did a lot. I actually, and what I mean by this is like, I actually did a little bit of research. So with that in mind, I think we can, do some good work. So here's kind of the plan. I was going to play some clips. I got some clips here. Dave Smith. He did this interview or this debate with Dennis Prager, Baccia, someone else, Cenk Uygur, and I talked about it last week a little bit. I'm not going to go into the debate too much, but then I just sent Dave a clip that was on the 5th column, and it's Baccia talking about the interview or the debate, and Dave he got a little antsy about it, so he's like, hey, so I sent him some clips, and then he does the thing. He's like, hey, I got to figure out how to post these. I'm like, okay. So I tweeted him out myself, and then he commented on him. Now, once again, you do these things, you go, by the way, I sent it to Dave. I wasn't at all, trying to like, hey, I'm going to tweet this. Please retweet it. That wasn't my deal. I just wanted, hey, I thought this was interesting. And then he wanted to make a big deal about it. I post the tweet, which is beneficial to me. And then he quote tweets me. Now, here's how dumb I am. I put the word Zionist in there, and I then went and edited it and made it a capital Z. Why? I don't know. But I did so. And then when he quote tweeted me, it didn't make it appear very well. It deboosted all the interaction. So really what happened was Dave got the credit for it, as he should. And I got... I actually lost followers, I think, from that. Anyway, look, this is kind of the whole thing. It's not my game. I do this for fun. We have good times. So with that in mind, I thought I would play, and I started it out a hard Z. Yes. Good to see some of you guys are in here. So here's actually the quote from the 5th column podcast. It only has Matt Welch and Michael Moynihan typically Camille Foster's on there as well, but he was not part of this one, and they had Batya. So here's what she says that got Dave riled up. Fifth Column Podcast, episode 451. Play it away. And it's muted.
Yeah.
There we go.
I'm like a cringe earnest person, so I went in trying really hard to find common ground, which I considered a huge win. I know it's so gross, but I forced in my attempt to do that, I forced both Cenk and Dave Smith to make what I thought to be pretty Zionist points at different parts of the debate. So I feel really good about that.
Headline, Dave Smith, Zionist.
Yeah. Convinced by Batya, who has an enormous Star of David on, by the way, in case you were not aware what side she was on. Just right there. But what was the argument that you got them, one of the two, to come a little bit towards your direction?
They both acknowledged that Israel had a moral responsibility to respond militarily to October 7th.
Yeah.
They didn't approve of the way it carried that out, although when I asked them, well, describe how you would have liked it to have happened, they described what Israel is actually doing. So that I felt, but I don't, like, that was clearly not something their audience, who were like the majority of the viewers, would have picked up on.
Okay. So Dave Smith, I'm trying to find it here. This is how bad I screwed this up. I can't even find the tweet that he quote tweeted me on. Okay, so that was part one. And I thought it was interesting that, and telling perhaps, that when you say, I've got them to admit some pretty Zionist points. Zionist points? How about humanitarian points? And by the way, it's totally disingenuous what she said or claimed that Dave did. Dave kind of took her on here pretty harshly. But let's play it just kind of a continuous. There's those three ones I got here. We'll keep going.
Like, my audience are not going to be watching this debate on this like weird, website. And it was then streamed on Breaking Points, which is very far left, and on the Young Turks, which is very far left. And then Dave Smith has a huge audience. Yeah. I think it actually was streamed on PragerU as well. But so it's like you're talking to people who really, really don't want to hear this. And it's hard because you want to, like I said, you want to do right by your people, your friends, your family, the people who you think have been misrepresented by everything. But on the other hand, you really do want to say it in a way that, like, Dennis Prager was speaking to his audience the whole time.
Yeah.
And I don't feel like I have that luxury, because what if there's like one person you could convince, not convinced to agree with me, but convinced that my view is a legitimate view. Yeah. And to do that, you have to go in acknowledging that the other people have legitimate views, which is why I think it's very important to choose your debate partners very carefully.
Yes. Even when it's not your choice. But I think that's an interesting way of framing it, because, I think most of these debates exist for the fans of the people debating to get or wait for a knockout punch. Totally. It's just saying, like, no one's going to be convinced by anything. You might get a couple things. And I appreciate the fact that you're trying to get a few people in the net behind the shrimp boat, like picking up weirdos that I'd be like, oh, actually, she has a good point. But usually it's just the echo chamber of people saying, like, like Dave Smith's fans or Dennis Prager's fans, or I don't know if they.
So
there.
Hang on here. So what's interesting there is, oh wow, this angle went really wide here. What's interesting there is that I think he's correct. You're not going to convince people necessarily. You may, because I think Dave has done. And by the way, I'm going to pull this up here. This is Dave. This is how stupid I went here. This is Dave's tweet. Okay, so he tweeted it here, and as you can see, because I edited it. He's got 162,000 views, and
going with disagree.
Here's mine, which I guess that goes to the video. It doesn't even really go to my tweet. So
I'm going.
That's I fucked that up so bad. But whatever. Fantastic, Tyler. That's superb. There, way to go. I don't know that you're going to necessarily convince people on some of those things, but what you are going to do, and this thing got all screwy here. Whoa, Tyler, my video stuff is all wrong. What you are going to do is you're going to be able to accentuate psychopaths. Okay, so people that are honestly, I mean, Dave talked about it on his next show. He's like, went out with Dennis Prager and everyone was pleasant. He's like, he was very nice to me. Maybe that's even more psychopathic, right? That you can basically say that someone like Dave is super evil for what he's thinking. That's what Dennis Prager is basically doing. And then be able to just go out and have dinner with him. That blows me away into some respects. But here you are. Okay, I'm going to play one more clip from this We the Fifth Column podcast. We the Fifth. It's the Fifth Column podcast with Batya.
Going to be convinced by anything. You might get a couple things. And I appreciate the fact that you're trying to get a few people in the net behind the shrimp boat, like picking up weirdos that I'd be like, oh, actually, she has a good point. But usually it's just the echo chamber of people saying like, yeah, like Dave Smith's fans or Dennis Prager's fans, or I don't know if the other guy has any fans. I suppose he does. But it was so, I tried to watch it.
It's hard. It was hard to watch.
It was a hard thing to watch. And I'll tell you why it was hard to watch. What you're saying about getting people to kind of understand what Israel was up against when they responded, there was a moment that I was watching where you were trying to establish something, and this is somebody who's doing a debate the right way, of what the civilian to combatant ratio of death is, because then we can kind of figure out if this is something that's gone morally astray. And people are getting very frustrated by that. Like, oh, we're done with the numbers. Okay, the numbers. I know you don't trust the numbers. It's like, no. It's very important to establish these numbers because the entire premise of it is you're indiscriminately killing children, women, civilians, et cetera. So if you don't establish that number, you're having a pretty hard time. And then there was a moment where it kicked over to the Cenk character. And I say character very advisedly because he was playing this unbelievable role, this bluster, screaming and being like, the Nazis and this. And it's like, you don't talk like that. Come on, man. That's not how you, it's like Joe Biden. Come on, man. You're not that person. But he was, I find it like.
All right. So I like Michael Moynihan. I think he's very intelligent. It is interesting that you look, and we talked about this not too long ago, that anti-Semitic laws, speech laws that are going into effect, if you question numbers, you're anti-Semitic. However, on the other side, they question numbers all the time, right? So it's just done without thinking, which is you can't trust Hamas's numbers. Yeah, maybe you can't. I don't know. I don't know that any. First of all, I'm thinking, how are we getting any accurate numbers at all in war like this? So it's perfectly fine to do so. And, then and by the way, Michael Moynihan or Batya, then don't mock when they're before Congress or you're asking, what was her name? The former Secretary of State, the little munchkin looking one that under Clinton. And they're like, kill 500, whatever young kids. Is it worth it? Well, yeah, I guess that's the price to pay. Look what we had to do, to burn bodies at Waco and whatnot. Okay, well then that's, and by the way, there is an analysis there. I don't know if it works in war, but Friedman used to talk about deaths with cars and that there's an actual calculation. And these car companies have done the calculation of what a life is worth and whether you go forward when there's problems, the Corvair unsafe at any speed or something like that. And so the Pinto and et cetera. So there are calculations, but I don't know that, war, I guess they do the same calculations, right? We have there. Okay, so that was a bit of a frustrating, It was telling. It's almost like okay, Batya, do you not think Dave's gonna get a hold of this? Maybe see this and go there. Was Cenk somewhat of a character? Yeah, I think so. But like I said, when I gave the analysis of this debate, I thought he was useful for Dave, which is. Okay, all the little crazy stuff that side is going to like to talk about, he gets to perform that. And then Dave looks sane, rational, bam, bam, bam. Now, there's protests going on campus. I hate protests. They're useless. There are people that have more time on their hands and they know what to do with. There is always good protest, I imagine, for whatever purpose, you feel strong about it. But it depends about how you go about this protesting. And I don't know that I have time today, but Norman Finkelstein evidently was speaking to, I think, the kids at Columbia University, the lefties there. And he's basically like, hey, stop saying from the river to the sea, because what have I said from starting at all talking about this, which is you see the Ben Shapiro's. I just saw my own congressman here in California, Kevin Kiley. He refers to, the protesters as pro-Hamas. Now, typically I push back on that and say, come on, just because you're anti what Israel is doing doesn't mean you're pro-Hamas. In a lot of instances with these protesters, it does mean they're pro-Hamas, and that's horrible. And that's what I've talked about with the anti-war side in general, which is from a libertarian perspective. Or you have something in common with RFK Jr., with perhaps vaccines, but he's a complete idiot on other things. I don't want to be used by these people. So That's why I don't even make comments about these protests, because I'm like, yeah, I hate them as well. But here's what's interesting about it. I listened to this morning show, and they used to call themselves libertarian. Even my wife's just the other day, she's like, I don't know, we need to find a different morning show. We need a morning show. No one has one. I know Austin Peterson has one. Like I said, no one has a morning show. Revenge of the Cis, I've literally never watched them. I tried to. A little cringe on Twitter, Mersh and Jose. I sided with Jose on that one. There's Dickie Masterson. I mean, I don't know. There's other morning shows. I do AM Wake Up. I had, what's his name on here? Jeez, he was a guest on my show. I do watch that one. So there, we do have a little bit, but we do need a morning show. Anyway, this morning show, they've come to the point where I think what happens is when you take these protests on campus and the outrageousness, then what happens is it justifies, for some reason, it justifies their bombing or their excitement of bombing in Palestine and Gaza and the West Bank. It somehow justifies it. And I don't know if that's the case. We're going to talk a little bit here about Harvey Weinstein and what happened with his hearing or his conviction got overturned, and prejudice that happens. And I think that's kind of the same idea, which is, let's not get, the protesting, it can prejudice your idea of the actual situation, and it shouldn't. It should not take that, if you were the judge, you'd say, discard this because it has nothing to do with the actual situation. These are people that are upset about perceived wrongs. Some of them, they have the facts right. Sometimes they don't. But them protesting in America should not taint what is actually going on, whether you like the protests or agree with them or not, or you agree with either side or not. Does that mean that then, okay, let's say the protesters start killing people on campus. Does that mean now that the situation in Gaza is okay? It's okay because the people that are against it are crazy. Well, but what about you think the Christian Muslim or Muslim, the Muslims or the Christians there, any of those people in Gaza that are getting their kids killed, do you think they're like okay with the protest? I mean, they're probably happy it's going on, but they don't really give a shit. They're just trying to survive out here. So anyway, interesting. We don't need to talk about that more. I just take a little bit about the debate last night. It was about open borders or closed borders. Is Mark Pellegrino? He's a actor. He was on Dexter. He's on Rust or some other show right now. I think he was some Lucifer as well. I actually liked him on Dexter. He got murdered there by Dexter. Fine. And I've liked him. He's a objectivist. So he's Ayn Rand, but he's kind of all over the board. By the way, the Ayn Rand is more minarchist-like, so I was confused as to why he was taking an open border stance, and I couldn't even really follow what he was saying last night. Seems like a nice guy. That didn't get heated at all. And then Top Lobster comes in there, and I think we'll play that clip real quick. Josie with let's see if I can find it here. So I clipped it off myself, but we'll use hers because she's show flash here. So I think this is probably the way to go. So Josie's films herself doing this, and see if I could pop it in here. So Top Lobster gets to come in here and make arguments. Now, before we go too far, a little spoiler there. Before we go too far, it started to degrade into conversations about Israel and Palestine. And then Mark suddenly is all jumping on the board there. And I will make a comment about his stance, which it was confusing to me at one point. But Top Lobster comes in, our boy Top Lobster, and he decides he's going to troll. And does he ever? So let's play this clip here. Let me make sure I have the volume going on. And there we go. Okay, so here we go. Top Lobster comes in to talk.
So go for Top.
Okay, Top Lobster, go ahead.
Hi guys, how you doing? Can you hear me?
Yes.
Yes. Yeah, I just wanted to say like how stunning it is. It's 2024 and libertarianism is still having the same debates between the same archetypes of people. Like you've got like a millionaire philanthropist playboy on the what I would deem as the correct side, and then you have a homosexual guy that's pushing anal sex that played Lucifer almost right on the nose, pushing.
Hey, wait a minute.
What?
Hey, buddy.
Talking to you. Wait. I'm just finishing.
Mark's not homosexual.
You're not going to finish anything.
You're gonna let me finish Taylor Swift. All right?
If we were in person, I'd choke you out. I'm not gay.
All right,
I'm not gay.
Mark's not gay.
And so don't call me gay.
Mm-hmm.
So don't.
Oh, you're not gay?
No.
I'm not gay. You may be. I'm not. So
I was listening to the entire debate, and then the last part about Israel really kind of drove it home for me.
But
I'm sorry.
It's all right. You're retarded. You're mentally retarded.
Right. So I laughed and aspirated here. Hang on. Okay, that's hilarious. So what Clint said to Mark, and I'm trying to get, maybe I'll get clips for this next time, but he asked Mark, he's like, hey, look, the people in Palestine or whatever, where do you live? And Mark's like, California. He's like, okay, would you just be fine with them all coming over to where you are since you're, for open border? He's like, yeah, absolutely. And I'm like, wait a second. If you're okay with them just doing that, then an even easier solution is just you take down the wall and they're able to go in Israel. Why is that not okay? You don't want to, you'll take them here, but not there. That doesn't make any sense at all. Chelsea does a great job of staying neutral here, says Lady. Yeah, I was trying to stay neutral. I did get the Mark Pellegrino follow from this, which is pretty nice. Or is it? Because then I was like, I can't dump on him with Top Lobster now on Twitter, or can I? You know what? I'm going to be just fine. I'm going to do that. Okay, so I want to talk here. I'm going to play some clips. This is Brian Nichols. I actually like him. He did a show had a lady come on, and I'm going to be playing some clips with this and then break down because from a law perspective, I have a few problems with some of the things she had. And for the most part, I think she was spot on. But I think it would be nice to get a little bit better perspective. And then one aspect, which is was a very problem. So hang along with me. This is Carrie Sloan. First clip here is going to be Carrie. Tell us a little bit about yourself.
In front of Kamala Harris in the past. So I have a personal affinity for wanting to insult her. I'm just going to be straight about it. So We the Female is a nonprofit organization that I created coming up on 7 years ago that was created out of necessity, not only for helping women learn how to embrace self-defense, but also helping them understand how self-defense laws, gun laws in particular, negatively impact their ability to protect themselves and their babies. So in short, we like to say that We the Female's entire mission is to arm the women with education, confidence, and self-defense.
I love that because here at the show, we like to talk about educating, enlightening, and informing. Yeah. So you're same church, different.
There you go. Okay, so that's kind of the setup there. I don't think she's an attorney at all, which does come into play just a little bit from my perspective. But I think she does some good work. So kind of her primary idea here is pushing, I think, two-way stuff throughout the nation. And with that in mind, for women, it's fine. And then with red flag laws and some few other items here. So I got to hang on here. This clip is about, this one was started talking about red flag laws or red flag laws.
Women's rights, but across the board, Carrie, why is this an issue when it looks at the Second Amendment and possible violations of liberties?
Yeah, it's a can of worms that a lot of people don't realize actually predates even 2018. The first official red flag law was put in place in 1999 in Connecticut after a lottery building shooting.
Snap. I thought it was not until Trump. So this has actually been in our political discourse for 25 years.
It has. But here's what's interesting is technically speaking, red flag laws themselves existed prior to an official law with a name on it, typically called ERPO or Extreme Risk Protection Order. Different states have different vernacular, but generally the common term, red flag law, they've kind of been in place unofficially for as long as we could probably imagine. Cops or family members could petition courts. It just wasn't a law. So now that they put these things in law, it's kind of changed the dynamic, but it's also given more power to the court system over somebody, and especially in some cases, in a lot of cases actually, without that person even being in court to represent themselves. And that's one of the biggest concerns. But a lot of the unforeseen circumstances.
Hang on. We will talk about this because look, if you've watched this show at all and you've heard any of my legal perspectives or the little things that are out there in the ether, My biggest pet peeve is when, and we had Brad Binkley on here, and he drove this home as well, which is nothing is worse than someone on your side that misstates an item to make it, I don't know if it's to play into their side more, or there's just maybe a misunderstanding. So I want to give this Carrie Sloan the benefit of the doubt, but this is a perspective that we have to dispel to some extent and then move on from there. Now, okay, so this is going to be the crux of this whole issue with here, but let's keep going. And by the way, that is where she says, don't get their day in court. Partially true, not true. And we'll talk about it.
Flag laws happen to be with domestic violence victims. Red flag laws were put in place, to protect people. And obviously the first people that we think about are veterans, right? Veterans was one of the big ones, school shootings, these type of things. But they're commonly used. And one of the first places that they were put in place in more recent years was in the Violence Against Women Act for domestic violence. In fact, the red flag laws that for domestic violence tie into the law, the regulation in the federal Violence Against Women Act that says if an individual is convicted, has a felonious conviction of domestic violence, they're permanently banned from owning guns. So that starts with domestic violence restraining orders. So I'm a domestic violence survivor. When I stood in front of law enforcement officers 16 years ago with fingerprints around my throat from being picked up from my throat and thrown around the room, I had broken teeth, I hadn't eaten in days. The law enforcement officers asked me if I had a place to hide when my abuser was being released after his arraignment. I was confused by that. I didn't understand why. And they said, well, that's because the chances of violence increasing is significant and highly likely once he's let out of jail, because clearly in the minds of the abuser, it's my fault he went to jail. Right. So interestingly enough, those cops at that time knew that restraining order that they were going to put in place wasn't going to protect me. But instead of teaching me or encouraging me to learn how to defend myself with a gun or any other means, but a gun is in my personal opinion, and I think a very commonly accepted one, it is the most effective self-defense tool for a woman, especially when we're talking about disproportionate size with an assailant.
Okay, so there's an idea. So let me talk real quick about different types of restraining orders. There's criminal restraining order, usually a protective order. There's civil restraining order, and then there's domestic violence restraining order. So the first one, the criminal, is the most harsh or the more difficult. It's beyond a reasonable doubt standard. It's criminal. Go to court there. That's the DA brings that. You may have a problem. The cops come, then they make a report, and then the DA is like, yeah, we're going to do something. We're going to push against this and press charges. I hate that term, but that's the DA doing that. You get to harass the DA until they actually do something. If they do, they bring criminal charges, and they have to do that. The standard of proof for criminal cases is beyond a reasonable doubt. You've heard about that. That's the hardest standard to get, and that's the criminal one. And typically they have the more harsh restraining orders, but it's a protective order that you can get for around 5 years or so here in California. Then there is a civil restraining order. That's you and your neighbor. I think that's clear and convincing evidence. It's a little higher standard of proof from the preponderance of the evidence, which is just a balancing test. That's the domestic violence one, but this is you and your neighbor. It's a little bit, it's not quite beyond a reasonable doubt standard, but it's, it's more likely than not, about 70% chance that this is true. And so that's what it is. That's you and your neighbor. Then there's a domestic violence restraining order, which is you have to have some sort of familial connection. You have a child with this lady. It's your boyfriend, girlfriend, aunt, uncle, whatnot. And that is just, clear and convincing is the top. Yeah. So it's just a preponderance of the evidence. This is more likely than not to happen. They hand these out like Pez, and those are very easy to do. Okay. So those are your things. That's kind of what she went over here. Okay. So now let's go to the next little selection here. Clip. This is, this one says defeating bad gun law studies. So this is important here we're going to make sure I have the right one. And here we go.
Because a lot of people have heard the talking point on the gun control advocate side that a domestic violence victim is 5 times more likely to die if there is a gun in the home. Well, I have that study, and I'm happy to link that for you for your notes later. That exact study that says that's actually 30 years old. First and foremost, it doesn't actually say that the victim dies by firearm, because typically when she's still home in that situation, she doesn't, and that's a whole other conversation. But the very next paragraph in that same study says a domestic violence victim is more likely to survive if she's left her abuser and has a firearm. It is the next paragraph in that study, but conveniently, gun grabbers don't add that little tidbit in because they only share each other's talking points. I can guarantee you nobody's ever actually read that study that talk about that because it's got information in it that they don't want you obviously to know. And obviously the cops knew that restraining order wasn't going to help me, yet they weren't willing to share with me information that could have given me something that could have protected me while he was stalking.
Okay, so she's talking about her own case, and by the way, we're going to get to a case she talks about here, and there's a lot of amicus briefs. So these are friends of the court. These are people that are like advocacy groups that are writing briefs to the Supreme Court in support or against either party, and it's interesting because we'll look through a different ones. All these victims' rights groups that are against guns, right? For the reasons she's talked about there, rather than for okay. Minder said he had to go before I leave. Do we like Carrie Sloan or no? Make the decision for me so I can move on. We like Carrie Sloan. We like Carrie Sloan. She does good here. She's advocating for guns for women. She's not a victim. She talks about, even though she literally was a victim, she talks about some really good stuff we're going to break down here. She's just wrong on one aspect, and it bothered me. It bothered me a lot because it's vital. Okay, and we can't be having misstatements of cases or facts because it helps us demonize the other side. Let's demonize them for everything they need to be demonized for, not for incorrect information. Okay, so let's now go. What's the next one here? 949. Okay, so here's what Brian Nichols does now. I like this. He has a friend, and this friend basically. Well, you know what? Let's let him describe it. I guess that's the best way to actually do this. Brian Nichols is going to talk about what the left perspective of red flag laws and why we should or should not pay attention to them. But here we go.
With red flag laws. And I said, hey, buddy, just do me a solid and give me your best arguments for red flag laws. Like just the best arguments you could. Here's what he presented to me. I want to hear what your thoughts are as I quickly read through these. So number one, he said it prevents gun violence and saves lives. The primary objective of red flag laws is to temporarily remove firearms from individuals who pose a threat to themselves or others and potentially prevents mass shootings, suicides, and other acts of violence. Even if it's only a small percentage of orders that being taken for red flag laws, it can save lives. That was one. Go ahead, respond. I want to hear it.
Okay, so there is countless amounts of data and statistics and stories out there. Unfortunately, the pro-gun side isn't as well funded as the anti-gun side for putting all that research together. I work for an organization called Crime Prevention Research Center briefly, and there's some data there. But for example, there was a story in what was the name of the city? Doesn't matter. It was Washington State many years ago, where a woman left her abuser, and he was red flagged under the Domestic Violence Restraining Order, under the Violence Against Women Act, and he had what we like to call the trifecta of protection for victims, or the victim did. The abuser was red flagged and had his firearms taken away from him. She had a domestic violence restraining order against him. Therefore, he wasn't supposed to be anywhere near her or come anywhere near her. And she was sitting in the parking lot of her children's elementary school, a gun-free zone. So she had the trifecta of protection that was put in place by legislation. He obtained a firearm and shot her through the window, killing her while her children were in the back seat in the parking lot right after Thanksgiving. So there's just one of many examples out there that show you that, at the end of the day, what it comes down to is if somebody really wants to get a gun to commit an act of violence, they're going to get the gun, whether they are under an order to turn them in or not. More importantly, we've seen time and time again with many of these school shooters that law enforcement, even the FBI in some cases, the Parkland shooter and the Uvalde shooter, they knew about these kids and they did nothing. So instead of trying to enact more laws or push for stricter laws, enhancing the laws that are already in place, why aren't we just enforcing the laws that are already there? And by enforcing those laws, why aren't we keeping these guys in jail? Why are we doing this catch and release business and letting them back out to reoffend when there is protections in place that would keep these offenders in jail?
Well,
okay. I like her response, very well reasoned. And she would go on to say, I believe here as well, she said it earlier, how about giving these women and telling them, get a gun to protect yourself? That's remember, she knocked down that study. So it's a vital aspect as well. Do we need to go any more on that? I think that's good. So that's first item. Then Brian had three of these things here. So here is number 2. see what this one's about. I believe temporary and targeted.
Because red flag laws, Carrie, are supposed to be temporary and targeted. He says that red flag orders are supposed to be temporary, typically lasting between a few weeks to a year. And the targeted individuals are usually folks who, to our point earlier, exhibit dangerous behaviors rather than just a blanket gun ban. So it's allowing intervention periods, but also being respectful of gun rights. But to your point, maybe it's missing a few other loose ends, i.e. if somebody is, having the intent to cause harm, they're going to cause harm.
I'm so glad you brought that up. What it also does in those cases is those types of orders can actually be used against people and domestic violence victims in particular. They can be used against a domestic violence victim by their abuser in several different ways. First and foremost, if there are firearms in the home that are owned by a victim. I know one personally, she was is a firearms instructor in California. She left her abuser. And it was a very ugly situation. Good old boys club. He was a fireman in the small town that they lived in. And so, of course, he was buddies with all the cops. He had her red flagged and had all of her firearms removed out of spite and malice so she couldn't earn a living. But then he started stalking her and starting verbally abusing her, to which we know that verbal abuse usually ends up in some sort of physical violence, especially if there was a history of it, which he had. So he used that law against her to disarm her, not only to in her case, to financially hurt her, but to also make her vulnerable. I've got several cases of women where abuse victims, where red flag laws have been used against them. Furthermore, those types of laws, and that's kind of what happened to me. It wasn't really a red flag law, but what threw me in all of this was 7 years ago now, back in Washington State, there was a law called I-1639. Some people may have heard of it. It came out right after the Parkland shooting. And it was a law that there was a lot of stuff in it, but the one thing that was in it that nobody talked about, and unfortunately ended up getting passed, is when you sign the 4473, which is that little form that gun control supporters think doesn't exist. It's a federal background check for firearm purchases. Spoiler alert, you are actually checked out. And how many of those are actually false positives, that's a whole other conversation that we could get into. Like you could have all these different segments on gun control with this kind of stuff with people that understand policy. So in Washington State, you can be denied the purchase of a firearm based on what they see in your medical record. Because when you sign that 4473 in Washington State, it's a waiver of your medical record so that the state health authority, whoever they are, gets to look at your medical record and determine that. So I know the question that's going to be on a lot of people's mind, well, what is it? Because I get that from my for my students in my firearm classes all the time. This is usually what gets centrist to left-leaning women, because the left-leaning women will come and they'll take handgun classes, right? It's the ARs they want banned, which I can usually change their mind on that too. But they go, well, wait a minute. I took antidepressants 10 years ago for whatever. I took sleep medication. I said, well, guess what? You could be denied. I said, when you go to buy your first gun, you potentially.
There you go. So that's your way of go. Okay. So important factors to talk about with that is using this red, and she says red flag, but the domestic violence restraining order, which is, and I'll explain the process when we talk about it in the next segment here, but you use it as a cudgel, right? So you're actually the abuser or the crazy person. I've had this. I have had cops as clients. I had very good guy, but his ex is certifiable, and she, said, he took the gun out of the gun safe. He was going to come get her. This is what the kids are saying, and what was fascinating for our side is she had timestamps of when this was happening, and he was literally in 3 cities over buying stuff at the time. So we had facts so we could. Anyway, we won. But as a police officer, he had to surrender his weapon, and then had to have a desk job for a while. And it took a long time. Even though we won this, you got to go to trial, and it took us a while to get there. It's several months. He's waiting. He had to turn his guns immediately, and then you finally get to trial on this. Then you win, and then getting them back was a pain in the ass as well. So temporary, yeah. Let's say it was against him. I mean, then it's it could be 2 to 5 years here in California. So okay, let's go to this last one here. The last question. This is the one I actually had the problem with. I mean, kind of. But we'll talk about it here. So this last one, red flag laws and due process. Here you go.
Thing here, and it goes right to the third point that he said that you've actually, I think, pretty much dismantled. And that was because red flag laws have due process protections. He said red flag laws typically include due process safeguards, like requiring evidence of a credible threat, a court hearing, and the ability to appeal an order. So it's balancing public safety concerns while also protecting civil liberties. But I mean, in the story you articulated where a fireman was able to get all of his buddies on board and was able to red flag his significant other, his ex-significant other, that doesn't seem to be really the case, does it?
Yeah, and so not only that, but it depends on how the laws are written in the different states. I do talks on red flag laws all over the country, and different states have different criteria. And California has actually passed a law where it's not just the law enforcement that can request it, but families can too. And just because somebody may have PTSD in their medical record doesn't necessarily mean that they're suicidal. In fact, we have data that
Okay, so all good so far. What you want to understand here is there are specific laws, actually red flag laws in California. It's a gun violence protection order where it could be a coworker, someone else that says, hey, this person's a little crazy, you need to look into them. And then they will go and have a proceeding, so to speak. We'll talk about that. So there's that. There's the domestic violence restraining order, and then there's the criminal aspect. So all of those ones I've described, and then the civil restraining order, all of those have a provision for when it's initially done on this temporary basis, you have to turn in any of your guns until a hearing. Okay.
shows that number one, that restraining orders don't actually keep women from being murdered, abuse victims being murdered. But we also have data showing that just because you take somebody's guns away from them doesn't mean that they're not going to commit suicide. In other words, there's no actual significant change of statistics for the rate of the suicide numbers, whether they have a gun or not. So in other words, the layman term of that, they're going to find a way to do it, whether they have a gun or not, essentially. So that is the biggest concern. And so a lot of people don't think about that. And one of the ways that I'm actually able to crack that is people don't think about that. But here's what's interesting. So a lot of these people, they kind of out themselves about the justification of due process, because just direct them to the Rahimi case, right? The Rahimi case was a Supreme Court case recently that was heard, and it's being heard as a Second Amendment right. And that's in itself is its own issue, which that's a huge can of worms. We should revisit that when they come out with the opinion on that, because that's depending on how they rule, they may have to go back and revisit Bruin. But how that whole ball got rolling with him is, look, let me be clear. That dude is not the dude that gun owners want representing him. He is a little bit of a piece of shit, just saying. True. That being said, one of the things that got his gut, so the case is all about him being able to own guns as somebody who has convictions. But I'm trying to keep this quick and short for y'all for brevity, but the conviction wasn't domestic violence. The conviction was for being in possession of firearms under a domestic violence restraining order. Interestingly enough, a restraining order that was issued to him by the court without him being present to defend himself. Right? Yeah, exactly. So, and now look, like I said, dude's a piece of shit, right?
Okay,
but,
so with that, I have to stop. I can't, this is when it comes to me, and I listen to this and I go, Carrie, you had me at everything, and then you say that, and Brian's exasperated. That's unbelievable that you would have basically your Second Amendment rights stripped from you without you even being able to appear in court. Except for no, that's not what happened. So I had to go. I knew a little bit about this, so I went back through. I listened to the full arguments in front of the Supreme Court. I listened. I read some of the briefs. I read the petitioner's brief for certiorari to the Supreme Court. That's the U.S. government. I read his response, and I will play some clips but let me break this down. Here's how this happens. When you file for a restraining order, now it sounds like this Rahimi. He's a bad guy, and we'll read some facts here, but here's how the process typically works. Someone, either you or like if you're doing a domestic violence restraining order. Now, his specifically was a domestic violence restraining order, but it went through the criminal court. So it was in Texas. I'm not sure exactly how that works. I'm going to explain California, and I think it's very similar. So the DA can bring a domestic violence restraining order against you as well, which they did. And when that happens, when they first initiate this we call it a DVRO, typically it's done what's called ex parte, which is with only one side. It's only one-sided. So let's say your wife, she's upset at you, or maybe you've threatened her, or she's threatening you. So you're going to file this. You file this restraining order, request for it to the court. It's an emergency, and the court takes it on a very low Rahimi. It's actually, I'll get the spelling here for you. It's here we go. R-A-H-I-M-I. Okay. And it was argued in November of 2023 before the Supreme Court. It was, and I'll try to put the links in the description. It has not been decided yet. It's got a lot, like she said, she's actually factual. It's got a lot of determination of what's going to happen here based on Bruin, which, remember, we broke down Bruin not too long ago. I think it was episode 156, talking about the illegal alien that had a gun. And the provisions for, and by the way, it's very similar code that he got nabbed up on. Flores, I think was his name, where he's an illegal alien in possession of a gun, and it's a statute code. And they're basically saying, according to Bruin, which now has to take a historical perspective of restrictions on guns, and if there wasn't one before, you can't have it now. And boom, they threw that one out. So that guy was actually a good guy, I think, Flores, besides being here illegally. He remember, he had guns because he was worried about the BLM riots. That I got guns during then too, okay? So yeah, not a problem there. Okay, so you file for a restraining order, you submit it into the court, you don't notice the other party, the court takes what you've done, and based on the facts of just your pleadings alone, they will either issue or deny a temporary restraining order. So she's right there, they don't have their day in court, but you are, I'm talking California here, okay? The most red flag, anti-gun state you want, that you do have to turn in your weapons if they're just known. But then you have a hearing set for about 21 days out. Typically, you got to have your due process times. So you didn't have it, and then they'll initiate this. But since they didn't have your full due process, they allow you to have that, and so you basically have a hearing set for 21 days. Now, oftentimes I go in there. It depends on what the situation is. Let's say there's kids involved. I might want, and dad doesn't have the kids now because the court said we're restricting your rights. That's very problematic. At which point, I'm trying to do as much as I can, as quick as I can, to get this resolved, to get the kids back. Okay, that's typically what I'm doing. If there's no kids and you don't have guns, because that could be another one. Like I mentioned here, I had a police officer needed to get his guns back. So we pushed to get this done as quick as possible, which means they need to be very cooperative, get me all the information we can. We file a response. Even in California, it's like, hey, if you need an extension of time to and you waive your time to come back, maybe another 30 days or so, they'll set a new hearing to be able to file a response. Each party is awarded that. The point is, you get your day in court. So she's wrong about, and by the way, I'm talking about Rahimi in specifically. He goes to court. Okay, maybe it's time we just bring up some of the documents for Rahimi. Okay. Petition on writ of certiorari. Okay, so let's bring this one in here, first one, because this is the government's. And by the way, it wasn't really even contested as to what some of the facts were with him. So, and then I'll play some clips here. And she's completely right about this guy being a complete piece of shit. And by the way, when he does his brief response, he goes in on a technical basis. The technical basis that maybe I'll just talk about it real quick, is he gets convicted of a domestic violence restraining order, which means you can't have your guns. His was a 2-year restraining order. You're supposed to stay away from her, no communication. They had a kid in common, all these things that work out. Supposed to turn in your guns. Later on, there's other crimes that they're investigating him for. They go into his house, they find weapons, they find the domestic violence restraining order filing with the guns there, and then they get him under USC 1522. I'm trying to remember the actual thing, which is basically if you're in possession of a weapon with a restraining order against you, now he's basically sentenced. It's a felony, and I think it's like a 20-year sentence. And that is the issue. Just that is the issue that's before the Supreme Court now with Rahimi, which is, hey, under Bruin, you can't actually be doing this. And matter of fact, his case was then appealed up to the district court, federal, because this is a federal statute they're talking about. And it was appealed, and they said, hey, under Bruin, we've got to dismiss this. I didn't even think they remanded it down to the lower courts. They just dismissed it. So that's the government brought this back up to him. Okay. Maybe I'll just read this real quick here. Brief in, this is the brief in opposition. Am I looking at the right one? I want to make sure I'm looking at the exact one that we need to have here. This is, United States v. Petitioner Zachary Rahimi, respondent on petition for writ of certiorari, brief in opposition. So that's not the one I wanted to bring up here. Oh, Tyler. Sorry, I had all these up and ready to go last night, and I just left them up here. Why is this not scrolling up here? It's 100 and some pages in this one. Okay, you know what? I'm going to go back to the original filings. There we go. Writ of certiorari. There we go. Okay, so I'll stop the screen here. I'll bring this one up. Now, this is the government. I walked through all of these just because I wanted to make sure. The government. So in his opposition he didn't even want the court to take this on, grant of certiorari. He didn't even want that to happen. But he being Rahimi argued specifically all the technical issues surrounding Bruin and whatnot. He didn't even put any facts into his brief regarding the alleged problems that were basically happening there. I'm going to go through theirs slightly because they basically weren't contesting that these things. Respondent Zachary Rahimi was a drug dealer who mostly sold marijuana, occasionally sold cocaine. Sweet. December 2019, Rahimi and his girlfriend had an argument in a parking lot in Arlington. Tried to leave, but Rahimi grabbed her wrist, knocking her to the ground. He then dragged her back to his car, picked her up, pushed her inside, causing her to hit her head on the dashboard. Realizing that a bystander had seen him, he retrieved a gun and fired a shot. In the meantime, CM is for the victim here, escaped the car, fled the scene. Rahimi later called her, threatened to shoot her if she told anyone about the assault. February 2020, after giving Rahimi notice and an opportunity for a hearing, a Texas state court granted her a restraining order, which was valid for 2 years. The court, and by the way, California, his actions here, I mean, you could easily get 5-year restraining order, which is kind of actually the maximum. This Texas state court granted her restraining order, which was valid for 2 years. The court found that Rahimi had committed family violence and that such violence was likely to occur again in the future. That's kind of the standard you look at for that. The court accordingly prohibited Rahimi from committing family violence and from threatening, harassing, or approaching her and their family. The order also suspended Rahimi's handgun license, prohibited him from possessing a firearm, and warned him that possessing a firearm while the order remained in effect may be a federal felony. Rahimi signed an acknowledgement that he had, quote, received a copy of this protective order in court at the close of the hearing in the matter. Okay, that's important part. Then there's some other things here. He then participated in a series of 5 shootings in December 2020 and January 2021. First, after someone who had bought drugs from him, quote, started talking trash on social, who hasn't been there, on social media, he went to the man's home and fired bullets into it using an AR-15 rifle. The next day, after colliding with another vehicle, he alighted from his car, shot at the other driver, fled, returned to the scene, fired more shots at the other car, and fled again. 3 days later, Rahimi fired a gun into the air in a residential neighborhood. None of this says it was during Cinco de Mayo either. That's odd. Fired more shots into the other car and fled. 3 days later, fired shots into the air residential neighborhood in the presence of young children. A few weeks after that, a truck flashed its headlights at Rahimi. When he sped past it on the highway, in response, this guy's lit. Rahimi slammed on his brakes, cut across the highway, followed the truck off an exit, and fired multiple shots at another car that had been traveling behind the truck. Finally, in early January, Rahimi pulled out a gun and fired multiple shots in the air after a friend's credit card was declined at a fast food restaurant. This is awesome. Police officers identified Rahimi as a suspect in all those shootings and secured a search warrant for his home. The search of his room uncovered a .45 caliber pistol, a .308 caliber rifle, pistol and rifle magazines, ammunition, approximately $20,000 in cash, and a copy of the restraining order. A federal grand jury in the Northern District of Texas indicted Rahimi for violating 18 U.S.C. 922 G8 and 922 A2. Remember, we talked about those statutes, similar ones that were all in that 922 section and 24, I think, with the Flores case, also associated with Bruin. Section 922 G8, which Congress enacted in 1904, prohibits a person who is subject to a domestic violence restraining order from possessing a firearm or in or affecting commerce. And they do talk about that in the Supreme Court case. At the time of Rahimi's conduct, a knowing violation of Section 922 G8 was punishable by up to 10 years. There you go, 10 years in prison. 18 U.S.C. 924 A2 218. Okay, so that's the main aspect of Rahimi, of some of those issues with that. Now, I want to see. This is a docket Appendix B. There's one of these I want to read, which talks about and lists his the restraining order. Let's see if I can find it here. Where is this at? All right, let's try to redraft this one here. Okay, I'm going to bring it up because we're going to basically look through some additional appendix. Let's see if this is the one which breaks down the actual. Okay, a record of the proceeding was okay. Let's read this one. Okay, some people here can. I don't know what you guys are talking about here. Oh, sounds like a future astronaut. Okay, appendix, which breaks down some of these findings from the lower court. The court finds that respondent received actual, okay, so let's start here. Agreed protective order. On the 5th day of 2020 appearances, applicant Cinta Medina Garcia, that's the mom, appeared in person and by Assistant Criminal District Attorney K.O. Kayan Williams and announced ready to proceed. Zachary Rahimi, respondent, appeared in person and by signature below, evidencing agreement to the entry of this protective order. So what happened was he ends up showing up to court. I'm sorry, Carrie Sloan, wonderful lady, but you can't be saying this case is an issue of due process and he never had his day in court. He went to court. He may not have had an attorney, but he did show up in court. This is the testimony and this is the record. Then they draft out, he pled guilty basically, and they draft it because look, we read the facts here. They don't dispute those as well. He then agreed to this restraining order of a 2-year restraining order. He signed for it, but it gets worse. Okay, well, let's walk through here. A hearing was held before Associate Judge Beth Palus, 324th District Court. A record of the proceeding was not made by court reporter. Okay, but they have documents here. That happens. Okay, a lot of times you could get a court reporter. Sometimes we do them electronically now where there's basically, I don't know if it's AI recording it, but you could get a transcript of the situation and you just don't have a live court reporter. Findings. The court finds that respondent received actual and reasonable notice because that's part of that USC 924 or 922G, which is the party to have this federal statute enacted against him. Now, look, I'm not a fan of the federal statute. I'm just going here about this triggered me. Carrie Sloan triggered me, and I needed to get to the bottom of what you're talking about with due process because I just had a restraining order. We're going back on it because guy wants it removed, but it was last year. You have to personally serve. That's part of the other part. Okay. So let's talk about this. This is almost invariably when and we're going to talk a little bit about rights here because you do have some problems with these restraining orders, which is you're getting a vital part, your Second Amendment rights are being stripped, and they are being stripped not under beyond a reasonable doubt standard. They're being stripped under preponderance of the evidence, which is it's crazy that this is the case, right? So anyway, that's more my problem, which is your standard of proof, which goes around stripping your Second Amendment rights based on sometimes very frivolous evidence that may or may not be true, but it doesn't have to be. So when you file a restraining order and it gets granted, you then have to serve the other person. They have to have and then to show up to court, you have to have them personally served. Okay. So you have to have a process server. You don't just get a mail because you get a mail a lot of service out to once you have the case going, but you have to personally serve them. So someone out there, they receive the document that says, oh, I'm supposed to be in court on Monday. Okay, fine. They go to court. I've had them where they don't show up in court. Then you get a restraining order. It's easy to get granted as long as you had personal service and there's a reason why they're not there. Okay, then we'll get to have this hearing. Granted a restraining order. I had this last year. And then what you have to do though is you actually have to serve the guy the order from the court. And once again, that's a personal service. So then if you weren't there and you want to have this motion set aside, take your time, go through those processes to do so as well. Okay. The court, having considered the pleadings and heard the evidence and the argument of counsel, finds that all necessary prerequisites of the law have been satisfied, and the court has jurisdiction over the parties' subject matter. The court finds that respondent and applicant meet a relationship. So they were having sex together, because that's part of the familial aspects you need here. The court finds that applicant and respondent are biological parents. There you go. The court finds that the family violence has occurred. The court finds that Zachary, respondent, has committed family violence. I'm skipping through, just kind of giving the highlights here. The court finds that respondent represents a credible threat to physical. Okay, so he's going to have going forward. The court finds that Rahimi, respondent, has agreed to this pursuant to Section 85.005 of the Texas Family Code. The court finds that a protective order for the protection of Ms. Garcia should be entered. The court finds that the terms of this order explicitly prohibit the use, attempted, or threat use of physical force application would reasonably to be expected to cause bodily injury. Confidentiality, we need to go about that. The court finds good cause exists to prohibit respondent from communicating. Okay. It is so ordered that Zachary Rahimi, respondent, is hereby immediately prohibited from committing family violence, communicating with Ms. Garcia, threatening through any of the family members to get to her in any manner, one or more family members or household. They can't talk to them or at least threaten them or use them. Zachary Rahimi may communicate in a non-threatening manner with her regarding the kids. Going within 200 yards of her residence, he can't do. Engaging in contact directly specific to her. I mean, possessing a firearm. Okay, there we go. Harming, threatening, or interfering anybody, custody, control a pet, can Okay. This is good. Back to the other part. It is ordered that respondent is prohibited from going. Okay. Prohibited having a gun. Prohibited from. Respondent is ordered to notify the court of change of address. Okay. It is ordered that attorney's fees. Okay. There we go. Okay. So then there was a protective order. And where is the main part I'm trying to get here? The clerk is ordered to send a copy of this order to law enforcement. The clerk is ordered to send a copy of this to the sheriff's department. The clerk is ordered to send a copy of this order suspending his handgun license service. This protective order was served personally on respondent in open court. Okay, and why is that? Let's see here. Signed by them. Order was signed and agreed and approved by. So he signed it. Zachary Rahimi, current address. I, Zachary Rahimi, received a copy of this protective order in open court at the close of the hearing on this matter. Okay, that's the part that I mean. So he was there. Okay, so what I'm going to do now here, I'm going to play a few clips from the actually. Let's make sure SCOTUS one. Here we go. From the actual arguments between open court.
Narrowly affords in this context, but I think it also runs counter to Congress's recognition and circumscribing of Section 922G8 to ensure that it's covering those who had notice and an opportunity for a hearing. And
Counsel,
therefore,
in the end, if there are due process failures in any system, that'll be subject to a separate challenge, correct?
That's correct. And Mr. Rahimi hasn't made a due process claim here. He's not challenging Section 922G8 on that
I'd like to go back to.
Okay, there's first aspect here. So he's not questioning. He's not making an issue with due process. That was the government's attorney, by the way. That's her claim. So let's go to. I have a second here. Clip.
Gotcha. And same thing goes with due process. We don't have a due process challenge before us, and so we don't need to resolve any of that either.
That's correct. He did not make a due process claim here.
Okay. And then lastly, some lower courts have recognized a duress defense to
We could talk about duress defense. I'm just playing all the aspects. I'm really sorry to do this to you, Carrie Sloan, but we're not gonna bring this guy up.
Underlying felony prosecution.
Well, you haven't raised a due process challenge.
Okay, now this is Rahimi's attorney.
With the underlying felony prosecution.
Well, you haven't raised a due process challenge to the underlying felony prosecution either, right?
Well, Your Honor, and again...
It's a Second Amendment challenge, strictly speaking.
That's correct, Your Honor. And we take that from Lewis. Lewis says what Congress intended when it passed the Gun Control Act in 1968 was those matters are off the table. So in Lewis, there's no doubt there is a constitutional violation and a violation of due process under this court's holding. However, there is no Fifth Amendment claim against a felon in possession prosecution, even if the underlying felony is concededly unlawful and unconstitutional. So we take that as a given when we come to a statute like this, that even if we could show a due process issue with respect to the issuance of the protective order, that would be no defense against the federal prosecution.
So what? This guy gets confusing here, and they even say at some point, "No, I'm really confused," and I don't think he does a great job. There's you got to kind of separate the different things. There was the state court domestic violence restraining order that got put against him, and then there's the federal indictment and federal prosecution for having a weapon after the fact. Okay, now he's still got all these other issues that we talked about that he's going to have to deal with. And likely he's going to go to prison anyway. So, no big deal, but he shouldn't have this enhancement, this federal enhancement under Bruen. And this could have wide breadth issues. Maybe they back Bruen off a bit. I don't know. I wouldn't have a problem with the courts actually saying. So anyway, he's talking about due process. There's two different due process parts here, right? There's the due process to the federal side, and then there's the due process on the state court side. This guy seems to think that what he's requiring now from the courts doesn't need a due process. And so I'm like, that's when I was like, okay, well maybe he still never was served this, is when I was going through this. And then you go back here and you're like, okay, look, here's the problem. They served him. He had to take his guns. He got his day in court. He goes there and they're like, look, dude, maybe we're going to go after you worse. If you agree to this, we'll give you a 2-year restraining order. I would be like, yeah, take the 2-year restraining order. It's only 2 years. And then you get this, get your guns back and you get everything back. That's not a problem. And he was in court. He was literally in court for this. He agreed to it. He signed this agreement. So you can't say he didn't get his due process. You can't say that the underlying issue was he wasn't even there to defend himself. And by the way, if you've served him and you've given him a notice, he has a chance to be there. That is one of the issues that's at. Now, once again, I will break this down and say, with that in mind, and this is the problem here, what you're doing, which is you're taking away someone's fundamental rights of being able to own a weapon, and you're doing it under a proof of standard, which is so easy to get, which is just a preponderance of the evidence, which is more like you're balancing the scale. Does it barely tip more than 50% on one side? Okay, well then there we go. Let's continue with some of this nonsense.
But if I'm wrong about that, I'm happy to hear it.
It would have been in the state prosecution.
I'm sorry?
It would have been in the state prosecution, potentially, in the state protective order proceeding, and you could have had a due process argument and raised it there.
You're right, Justice Gorsuch, and that gets to a really important point here. Because Congress has made this sort of a per se automatic disarmament, and it has tied it to the issuance of a protective order, there is no due process required before a court enters an order enjoining me from committing physical abuse against someone else. That is not a protected right. So what we have is a proceeding that's designed to adjudicate small rights or no rights at all, and then based on the results of that proceeding, and even the findings that are entered in that proceeding, we take very consequential actions that go against an individual's.
Okay, so he's kind of expressing exactly what I said, which is we're doing like inconsequential things, shadow protective order, and then it has wide-ranging ramifications for your gun rights or your and that issue. The problem he has is his guy is a scumbag, okay? And they even kind of mention that here at some point. So he's got to work his way. I think he's on the righteous side of the gun side, but he's this scumbag. As Carrie had even mentioned, or Kate, or whatever, Miss Sloan.
Fundamental right to keep arms, of citizenship.
Yeah.
So I do not believe, at least I'm not aware of any due process that would apply with respect to the part of the order that 922G8 cares about. The one that says you cannot abuse that person. And so in that sense, there's no due process claim we could raise. So that's the thing. Congress has taken a big right, the Second Amendment, and has...
You're not saying that before a protective order is entered, there's no due process rights that an individual has, are you? I mean, is that the position you really want to take?
For a G8 order, so an order that forbids further abuse?
I'm talking about in state court.
Right.
You're saying the due process clause is silent before a protective order can be entered against an individual?
To the extent that the only remedy granted by that order is forbidding abuse, forbidding physical abuse, I don't think that you have any right to due process before that is entered, because you have no right to abuse anyone. It's just not. The incentives.
You have no right to murder someone, but we give you a trial.
Right. So,
and this is the sad part, which is this attorney can't differentiate between, and he's having a hard time with it, which is the state court thing, which Gorsuch is like, yeah, you're not bringing a due process claim, are you? Why not? Well, because he was served a process. And I'm now pushing back on this federal statute that we have a problem that Bruen doesn't deal with. But yet he's got a problem because his guy's a scumbag. So you kind of have to dance around.
So there's always process before a right or a life, liberty, or property is taken from you of some kind. What measure of due process depends upon facts, circumstance. But I'm not talking about that. But I'm surprised to hear you say that the Fifth and the 14th Amendment's due process clauses don't apply to an individual who is being subject to a protective order.
I think depending on what the protective order required. So that those probably do kick in. In the same way that if this were a true disarmament proceeding, so this court I don't think has announced the criteria that would be required in something like a red flag law.
Oh, whoops. Okay. I'm sorry. That's back.
So everyone's attention is focused on the loss of firearm rights. There would be certain requirements, and we could argue about it. I would submit it would probably need to be clear and convincing evidence, but it would certainly need to be fundamentally fair because this is a fundamental right. That's not what any state does for a civil protective order. There's typically no incentive and often no real opportunity to contest the issuance of the order. And in many cases, people are happy to consent to the orders because they don't want to be around the person anymore.
Counsel, I just want to clarify. What? You're right. You don't have, the right to commit violence against anyone. But this protective order says a whole lot more than that. I mean, he's prohibited from communicating with his family, with going within 200 yards of her residence. So I think that paints a little bit of a different picture in the due process rights that might apply.
I agree, Your Honor, that the due process clause would impose limits against involuntary termination of access to one's children, for instance. So I don't mean to suggest, and Justice Gorsuch, if that's what I implied, I didn't mean to. I don't mean to suggest that the due process clause doesn't matter what happens in one of these proceedings.
So, Mr. Wright, may I ask just about your basic argument here?
Okay, I guess not. Let's add to the stage here. These are all the filings in this case, and these brief amicus curiae of California Governor Gavin Newsom, as an example. You look through that; these are all in favor of not having this proceed. They're in favor of this state. Okay, New York County Lawyers Association, Illinois. Josh Horowitz. I'm not sure about which one he is. I didn't click on all of these, but I know. I've gone through some. There's a disturbing one or two down here, which is California Legislature's Women's Caucus. I mean, come on. National Indigenous Women's Resource. Now, the Second Amendment Law Scholars. Okay, there you go. But there was also religious leaders and organizations. These are for the state. This is disturbing. There was like some Catholic, Amy Klobuchar, gun violence and domestic violence prevention groups. These are shit groups here. Global Action on Gun Violence, Prosecutors Against Gun Violence, California Governor Gavin, he just can't stop doing this. March for Our Lives, Giffords Loss, Gabby Giffords, Texas Advocacy, Citizens Crime Commission, United States Conference of Catholic Bishops. Wait, Professor Mary Ann Franks, I don't know. Houston. Okay, so it's a bunch of really shit groups joining in to get their data. Why is a woman talking? Yeah, well, don't worry. We cut her off. Okay, so here's what I have to say, Miss Sloan. You did a great job. I enjoyed your podcast. You have a lot with Brian Nichols. You had a lot of good things to say, but you can't be so fundamentally wrong on the facts of a case when you're trying to point out the due process just doesn't happen with gun rights or red flag laws, domestic violence. That's not true. You are going to get your day in court. And I'm just saying the process itself may not be great, but you get your due process. In other words, you get your day to go in there and make a show trial or a monkey court. Okay. So the stop and this dispel from that is as long as, and this is the problems I have even with, men's rights groups, when you're talking about family law and whatnot, and they bitch and they complain and you're like, okay, I get this. Clients come in and they tell me a story. I just had one here. He told me it's this sob story about, paying thousands of dollars a month for support and I finally get this stuff and they're just like, you're completely wrong about what you're telling me. I'm looking at the facts here. Oh yeah, well this, and then he starts to explain. I'm like, but who are you telling your friends? I'm sure you're out there complaining about stories and those are bad enough. Carrie, what's Miss Sloan? What's this? Carrie Sloan. Please don't exasperate these situations by giving facts that aren't true. And I'd love to have a nice discussion with you, but we're just gonna we might have a problem here. let's see. There's a why are women talking? The women's caucus sounds like something Blair White would be involved in. Blair White is tucking caucus. Yeah. Yes, it is. Solid stuff. Okay, so last thing I want to get to is overturning Weinstein's, and this is where we come into. Look, I'll play a little clip here. Let's see if I could do this. Maybe you haven't heard Harvey Weinstein. He was the big Me Too people. So he got convicted in New York. He had a trial in California that I think there was a hung jury on. There were some issues, but let's see what this news thing says. Weinstein's rape conviction is thrown out. Harvey Weinstein. Why am I playing this? I thought this was actually a news thing, but it's not. Ashley Judd. I don't want to read that one. There's a different one I wanted to read here. Oh, yeah, let's do this. The Aussies actually produced a little news bit. So let's. Damn it. Let's go. Let's play a little bit of there. Okay, here we go. Oh, Jesus.
Praised Hollywood producer Harvey Weinstein has had his rape conviction overturned by a New York court. Let's go live to US correspondent Marley Hogan now. Marley, good morning to you. Now, of course, this decision has absolutely devastated Weinstein's accusers.
And Mon, good morning. A lot of sadness and frustration from those accusers this morning. This is a decision that has really sent shockwaves right through Hollywood and the entire entertainment industry.
This is what it looks like when you've spent too much time in prison. I guess you need a front wheelchair.
Investigation around Harvey Weinstein is really what sparked and fueled the Me Too movement. More than 100 women came forward with accusations, and back in 2020 he was convicted of assaulting 2 of them, and that did include being found guilty of rape. But today the highest court in New York has overturned that decision. The New York Court of Appeals, in a 4-3 decision, found that he did not receive a fair trial, and they have pointed out one crucial mistake that the judge overseeing that trial made, and that was allowing the prosecutors to bring forward a series of women as witnesses who made accusations against Mr. Weinstein, but those accusations were not part of the charges that he was on trial for.
We are devastated.
Yikes.
For the survivors who are connected to this
That's the
case,
founder of the
and
Me
the
Too
survivors
movement.
who had found some solace.
I'm sorry. She's like, what about me? Me too. I want some.
Solace and catharsis in the original verdict around Harvey Weinstein. Because these brave women in this case broke their silence, millions and millions and millions of others found the strength to come forward and do the same.
Now, this decision does not mean that Harvey Weinstein is a free man this morning. In 2022, he was also found guilty of raping a woman in California and was sentenced to 16 years in prison for that. Now, this ruling could lead to a new trial, and a spokesperson for the Manhattan's District Attorney Office has said that they will do everything in their power to retry this case. Mon.
All right, thanks very much, Marley Hogan, for us there. Here's Shep.
I don't know why I played the Australian version, but there you go. So, holy crap, her nose. But he's people said he's still not off the hook in California. Exactly. He's got a 16-year sentence. You just heard it there. He was convicted of rape in California. Cosby's out. Weinstein's out. We're only a few months away from Ghislaine being set free. Holy crap, her nose. Yes, exactly. So let me read a little bit of this, and then I think I'll talk about kind of some of these, and I went through I don't have time to go through the whole ruling, but I could give you some understanding of why this is significant, and I think it's somewhat important. So here's go. What happened at his New York trial? This is CNN, of course, but it does match here. New York charges were directly based on the testimony of Haley and Jessica Mann. Haley testified that Weinstein forcibly performed oral sex on her in 2006. Just pee on him. I don't know. And at his Manhattan apartment, and a man testified that he raped her in 2013 during what she described as an abusive relationship. In addition, 3 other women testified to the trial as to, quote, prior bad acts. Witnesses and prosecution sought to show how Weinstein had a pattern of abuse. These women, Dunning, Terrell Wolf, and Lauren Young, each said Weinstein used his Hollywood influence to take advantage of them. and they were young and hoping to break into the film industry. After Weinstein was convicted in his New York trial, his attorneys appealed the conviction. They argued the judge should not have allowed these prior bad acts. Witnesses to testify should not be given prosecutors the ability to question Weinstein about instances of verbal abuse and bullying on cross-examination. Weinstein ultimately did not testify in his case. We conclude the trial court erroneously admitted testimony of uncharged alleged prior sexual acts against persons other than complainants of the underlying crimes because of the testimony served no material non-propensity purpose. The ruling written by Judge Jenny Rivera. It's a female. And I think she was Sotomayor's law clerk. She's done other things. So she's kind of a bleeding heart liberal. So, take it for what you will with this ruling. The court compounded the error when it ruled that defendant who had no criminal history could be cross-examined about those allegations, as well as numerous allegations of misconduct that portrayed defendant in a highly prejudicial light. The synergistic effect of these errors was not harmless, yet in a stinging dissent, Judge Madeleine Singas wrote that the majority opinion perpetuates outdated notions of sexual violence and allows perpetrators to escape accountability. And this is what you get sometimes with, I see this with the Supreme Court with some of these female judges with their rulings. It's emoting rather than, well, is this the law? Did this take the, and then this conclusion deprives juries of the context necessary to do their work, forecloses the prosecution from using an essential tool to prove intent, ignores the nuances of how sexual violence is perpetuated and perceived, and demonstrates the majority's utter lack of understanding on the dynamics of sexual assault. She wrote, because New York women deserve better, I dissent. I don't know. Do they deserve better? Well, here's part of this thing. Prior bad acts, there's a evidence code, federal evidence code 404 or something like that. And then there's also, 404. And then you also have the New York Code about prior bad acts. New York evidence, prior bad acts is generally not admissible in criminal trial except limited circumstances. Under Section 421, evidence of past crimes, wrongs, or other acts may be admissible under certain conditions. One exception is the Molyneux exception, which allows evidence of prior bad acts to be admitted if it serves as a background about the relationship between the parties or establishes the intent, motive of the defendant. This exception is often used in domestic violence cases where the prosecution may seek to introduce evidence of prior acts of violence or abuse to show defendant's intent and motive. And here they're saying it was too prejudicial, and some of these didn't even work. Matter of fact, they had one or two of the ladies testify in the case from California that had been a hung jury. So it's just some oddness here. Now, here's my deal, and the reason why I think this is important, which is we are seeing a lot of problems with Trump, as an example, in this selective prosecution going on in New York, and in other states as well, in other districts. And when this happens, and the judge just kind of lets this stuff go. Now, remember, is Magoo in here? Read 19th Amendment and right. Mark Pellegrino is out. When you look back at the Wisconsin case, this guy's always named Brooks, I think, and he was the sovereign citizen there. That judge took painstaking efforts to make sure that, one, as an attorney, you've got to put things on the record, right? If you're going to object, things aren't going quite right, you put objections, it's on the record, and those are reasons for appeal. You don't get to have an appeal because the case went against me. No, it's got to be for certain reasons. And when judges allow shit to go on in their court, and this would Weinstein have been convicted but for this? Yeah, he probably would have been anyway. So it was unnecessary. It was an overload. And then you're pushing these areas where you are going to get an appeal, similar to, I don't remember the full situation with Cosby, but his was it might have been evidence obtained, without a warrant or something like that. It was totally on a technicality, but it's also like, well, then stop fucking up. You've got a lot of losers that work for the state, and whether it's the police themselves, the investigators, the DA and their minions. And you see this with the Trump thing there in New York as well. And then they go ahead and push the envelope, and then you got ridiculous judges that are going to go, and you know what? Fine. I would rather have this happen because we need to have people put away for proper reasons. And this, he's obviously would have been guilty regardless. But or maybe not. I mean, there was a hung jury in California. Who knows? But more likely than not, he's somewhat of a scumbag. But you got to protect this so that when the actual people that are coming through the court systems are getting railroaded because the police just aren't doing their job, or the DA just wants to get a conviction, then, you make sure that the situation's set up so that they get their due process, right? And we talked about somewhat, it's similar to this. This went back to the Leo Frank era case, which at the time there was, you can't just bring up someone's character. Okay, this is kind of what you're looking at here. Instead of mode and operation, you can bring these prior bad acts. So like this person does these certain things, and then you can tie it to how these situations were, that it looks the same, it mirrors them, but these weren't all the same. So that was part of the problem you had with this one as well. But back in Leo Frank, you couldn't bring just a character of the person except for to rebut. So Leo Frank goes in there on his defense and he's bringing these people about like, what a great person I am. I'm so good. I would never, diddle a 13-year-old girl and string it on and blame a black guy. So they're like, oh, okay, well, maybe you say that. Now we get to bring character in as well. And no, you are a diddler and you're a disgusting man. And that's what you've been doing. Okay. JC says, my favorite thing about right-wing Twitter is all the E-trad girls that complain about things like 19th Amendment jokes. Oh yeah, that Ashley St. Clair is she's going crazy lately, and she's somewhat pathetic. So you know what you do? You block. Now, JC brought up a great point yesterday. He's like, "Hey, I thought you blocked all women on you block all women on Twitter." Now, some of them I mute, some of them I block, but the Josie one, we had a problem a few years ago. I have problems with people simping for her. But she did reach out to me to give her some help. And I was like, sure. Is this going to benefit me? Sure. It benefits me a little bit. So I had to unblock, and then we joined up and I had a good conversation with her. But you know what I'm not doing? I'm not like having multiple conversations. I'm not really joining in on any of her stuff. So it's what it is, JC. Sometimes you gotta, whatever. Yeah. It was JC that said that to me. Hey, dumbass. You say you don't associate with these females. I typically don't. So we're going to end here on, let's see if I could find it. Going to Tyler's Twitter. We're going to go look at media, and I'm going to see if I can find this one. There we go. This is a Cole edit I made. This was of his amazing tweets, basically about his wife, but this one I added music to. So JC says simp. True. Not going to totally deny it. Okay. We're going to play this one with Cole, and then we're going to be out. And then, I gotta just say, by the way, people, I appreciate the comments. I can't tell you how I came in here last week and I was like, I felt so, Top Lobster, Jose, Toad, Clint, who am I missing? Cole. Not one of them made a comment about my video that I had done for Talking Towers, which was 4 minutes, a little too long. Not one of them had done it. And then you guys said, hey, you know what? It was good. And someone's like, hey, I found your show because of that. And I was like, you know what? Thank you, audience, for standing up for me. So then I posted. I was kind of embarrassed. I was like, I can't even for a few days. And then you guys said that, and I was like, okay, fine. So I posted it on Twitter. And you know what? You know who retweeted it? Sam Tripoli. So is Sam Tripoli funnier than all those other guys? I say yes. He probably is. Okay, let's go here. Let's play this clip with the music. The music is significant. And Adam, my friend on Twitter, he suggested, hey, put some boomer music under this. Here we go. Tori Amos.
Excuse me, but can I be you for a while? My dog won't bite if you sit real still. I got the Antichrist in the kitchen yelling at me again. Yeah, I can hear been saved again by the garbage truck. I got something to say, but nothing comes. Yes, I know what you think of me, you never shut up. Yeah, I can hear that, but what if I'm a mermaid in these jeans of his with her name still on it. But I don't care, 'cause sometimes I said sometimes I hear my voice, and it's been here, silent all these years.
All right, we're done with that one. Come on, shut up, Cole. All right, that's what I got. Thanks for hanging out with me on a Saturday. Once again, we'll be back on a Friday. And so hopefully next week, you guys have a good time. We'll see you on Talking Towers. Lainey, glad to see you joining here, and JC and all you guys. Lainey, your edits, once again, killing it. Appreciate y'all. Take care, y'all.
Okay, I'm leaving now. Bye, guys.
But she's back.
And now.
Chick-fil-A is completely overrated. It's not that good. I prefer Zaxby's. I prefer Popeyes.
Takes a tough man to make a tender forecast, Nick. And I guess that's me. Keep fucking that chicken.
Should I vote for Dick Cheney on the Libertarian Party? Do I have an obligation to vote for Dick Cheney?
I would say so.
Yes.
Did it work for those people?
No, it never does. I mean, these people somehow delude themselves into thinking it might, but it might work for us.
That one dude was like, not a podcast, I can't find it anywhere, and they don't have video.
Oh, yeah, Peter Janke, yeah.
Yeah, I blocked him.
I'll do it. If he unblocks me, I'll...
He'll buy your shirt if you unblock him, Bert.
He's a wigger.
Yeah, nothing cooler than a 49-year-old wigger.
Like,
I just started live streaming. Cut me some slack. I'm pretty high tech for a boomer. But anyways,
boomer.